I'm Rob Sterne, founding director of intellectual property law firm Sterne, Kessler, Goldstein Fox. Today, I want to talk to you about a critical topic in the current Patent Office litigation landscape: court stay factors in current post-grant proceedings after the American Invents Act. Now, in a large proportion of the inter-party reviews under the new American Invents Act, and in all of the covered business method reviews, there is a parallel litigation ongoing in either the district court or the International Trade Commission, or both. Now, the statute that created the new inter-parties review does not require that the judge in the parallel proceeding in the district court or the ITC stay their proceeding pending completion of the IPR proceeding. However, the district court judge or the ITC administrative judge needs to determine whether or not a stay is warranted. Now, based on the initial wave of these IPR filings, I would say about 75 to 80% of the courts are actually granting stays in these parallel proceedings under the idea that they are wasting valuable judicial resources if they continue on before the IPR proceeding is completed. But many judges who are very informed about the new IPR proceeding are taking a more considered and nuanced approach. They are looking at many factors in making their decision about whether to stay their proceedings, and I would predict that in the future the percentage of stays in parallel litigation will actually go down as judges become more informed about the various factors that they need to look at to determine whether or not the stay should be granted. These factors are many. For example, where is the new proceeding, the IPR, relative to the court proceeding? How do they match up time-wise? Has the board, the Patent Trial and Appeal Board, instituted trial on all of the claims that are in the parallel litigation, or has it only done it for some of the claims, which is often what the board does? Another factor is, have they actually, namely the board, made a decision on whether to institute trial? There is a certain percentage of these IPRs where no trial is ordered at all, and it would make no sense for a district court judge to have stayed if the board ultimately does not order trial. Remember, these are valuable patent rights. This is what is argued to these judges, and the delay in having their trial proceeding conducted is one that they never give back. There is no proceeding or available statute now that gives back the time that the patent is in these proceedings back to the inventor if the inventor is successful in these post-grant proceedings. So in other words, if the post-grant proceedings take 4 years, the inventor, the owner of the patent, does not get those 4 years back while the process in the IPR proceeds. Turning to the covered business method proceeding, the way that is set up is that in order to bring one, you either have to have been sued or threatened with suit. So in all of the CBMs just about, we see a parallel proceeding. But it is also not required by the court, that the court stay its proceedings in a CBM context, though most have. But there is an interlocutory appeal of the stay decision, regardless what the district court or the ITC judge does in any CBM proceeding, to the Federal Circuit. And turning now to the future post-grant reviews that will be available for AIA patents, as they are called, the same factors most likely will be applied by the judge. So in sum, judges are confronted with a very complicated situation in deciding whether or not to grant a stay if there's a parallel post-grant proceedings. My recommendation is that the court be provided with all of the various factors and variables that are ongoing between the two proceedings in order for the court to be able to make the best decision possible. Thank you very much.